Hello and welcome to Reading the Receipts, the weekly uneducated recap of the Blake Lively versus Justin Baldoni docket. And welcome for the very first time today. This is the first stream I'm doing. I totally did not start this stream 30 minutes early because I was just so anxious about getting started on time. So apologize for everybody who's about to hear this for the second time, but welcome into everybody else. So yeah, we'll get started. As always, our legal disclaimer, we're going to look at some legal documents, but I am not a lawyer. I'm certainly not your lawyer, and none of this is legal advice. All of the allegations we're going to cover are just that. They're allegations and have not been proven in court. Nothing we're going to talk about should be taken as fact, and all of this is just opinion provided for entertainment purposes only. Good to see you, Mukamuck. Have not already seen you so far this morning. This is the first time we're meeting. My lady, hi, good to see you too. I will put this down to doing a early Sunday morning stream where I have not yet finished my coffee. So that is part of what the problem was this morning, but I appreciate your grace and patience. And not one of you said, you're starting this stream 30 minutes early. So thank you. Thank you for bearing with me. All right, we got a lot to hit up on the docket. I had talked endlessly and again, I apologize, Mukamuck. You're going to have to hear this again. I've talked endlessly about how Wayfarer needs better legal representation. We've talked specifically about Jennifer Abel as well, getting her own, and that their best interests are not being served by their current lawyer. We're going to talk about that again today. There's going to be a lot of just really bad lawyering, I think. And again, opinion from me, somebody who's not a lawyer, not trained in law. And to kind of start off, we're going to go to a case that is not the Baldoni Wayfarer case. We are instead going to go to Vin Diesel, who is also being represented by Friedman, who is also being accused of sexual harassment and retaliation. And this week apparently tried to start a fight with opposing court, with opposing counsel. Hi, Gina Richardson, good to see you. Sophie, good to see you too. Miley says I'm going to be half in here and half watching Link Click. My poor monotropic brain may not be great at this. No worries, no worries. So yeah, what happened is that Vin Diesel was scheduled to appear for his deposition, did not appear for his deposition, and so there was a meet and confer that happened between the two lawyers, and Friedman tried to start fights. Now, TMZ does say a source close to Friedman tells the TMZ the claim is BS, that it was actually Hale, the opposing counsel, who was the aggressor, claiming he leaned forward towards Brian and started screaming at him when he found out that Vin Diesel wouldn't be at the deposition. Our sources claim Brian never cursed or raised a fist to Hale, adding the allegations are totally false. Now, if you'll notice, this is exactly the same nonsense that they did with the Taylor Swift stuff, right? If he makes statements to the press, those statements to the press can be used in court. So if he goes on record, if Friedman goes on record and says, I didn't do those things, and he did, then he would be lying and he would be in trouble. So instead, we have a source instead. That way that Friedman isn't legally liable for anything that this source says, but he still gets to put out his side of events. The problem for Friedman in this case is that the opposing counsel have added this as part of their motion to compel Vin Diesel for his deposition, but they've also made a declaration talking about Friedman's behavior in this case. So he made this declaration under oath, under threat of perjury, and it says, during this back and forth, Friedman entered the room. Hale again requested to know why Mr. Diesel was unavailable, to determine if this was a true emergency or Diesel just simply failed to appear for his deposition, for which availability had been cleared over a month prior, as it would be important for the purposes of any motion to compel that needed to be filed, which they have now filed. Counsel for the defendant continued to refuse to provide any explanation, and then Friedman interjected and told Hale to just file his motion and called Mr. Hale a moron and cursed while doing so. Hale began to write down the language on notepaper, specifically stating that he would be including these insults in his declaration to any motion, which he has now done, and requesting to have a professional and substantive meet and confer. Friedman then threatened Hale with malicious prosecution and called him a piece of... At no point did Mr. Hale exchange any insult with Friedman, raise his voice, or provoke any physical contact. Shortly thereafter, Friedman got up from his chair, rushed to stand directly in front of Hale, mere inches away from him, causing Friedman's face to be directly in front of Mr. Hale. Mr. Friedman then called Hale a pussycat, but without the cat, and swung his fist at Hale's face, stopping directly in front of his face without making contact. Shocked, Hale nonetheless remained composed and attempted to address Mr. Hardy behind Mr. Friedman in hopes that counsel would get the meet and confer discussion back on track. At some point shortly thereafter, Friedman left the room, and Mr. Hale and Mr. Hardy conducted the meet and confer session, both then and after the deposition concluded later that day. This is so wild. Basically, your lawyer is trying to throw punches at opposing counsel and calling them all of these names. So they have filed a motion to compel for Vin Diesel's deposition. They have also filed for sanctions against Friedman as well. Now, I have not fully looked at the documents in this because it's about $100 worth of documents, all of this. I mean, Hale's declaration here, I think, is like 400 pages. It's a lot. So it's like a $40 document just by itself. I'm not that interested in the case. I will, however, absolutely be pulling the document that is the judge's order on this motion to compel to find out if sanctions do end up against Friedman, though I'm sure it'll probably be reported in the press. So that is wild. And it's also a mark against Wayfarer and Baldoni, right? If your lawyer is throwing punches in a different case and you still are using him, you haven't gone to your law firm and said, hey, we don't want him representing us. He's out here throwing insults, cursing, and throwing punches. We need a different lawyer. That is you showing that you are fine with that behavior. You are enabling that behavior. And again, this is all the same behavior that he's been doing in the Blake Lively case, especially with this source close and talking to TMZ. I mean, like, we've talked before on one of these episodes about Friedman's history of continuing to use smear campaigns and TMZ to do these fast social media campaigns and harassment campaigns in order to force a settlement. And he's doing it while in the Blake Lively case denying that that's his MO. That is brazen and bold. Anyway. All right. Using fists instead of facts, said Sophie. Yes. Kira, good to see you. Kim, good to see you too. And Spring Violetta. I cannot wait for the day that Friedman is disbarred. Same here. I don't understand how he's not. I mean, like, this alone should be, up for professional conduct or something. I mean, 100%. And Sophie says he should already be in jail. I'm still disgusted about that case of how he admitted to everything and that, essentially admits to engaging in an act with an intoxicated minor, and that's okay. We're cool and comfortable with that. I mean, even admitting his side of the story, it was still sexual contact with an intoxicated minor who cannot consent. There's a word for that. Anyway. Moving on, what else did we have this week? So we also had, the judge gave an order to both Lively and to Jed Wallace regarding his motion to dismiss himself from the main Wayfarer versus Blake Lively case in the Southern District of New York. The judge wants Lively to basically file 2 pages responding to the argument made by Wallace that Lively never identifies any specific co-conspirator committing any specific act that qualifies under 302, an act taken while physically present in New York, that she is seeking to impute to Wallace through the conspiracy theory jurisdiction. And then she has to file that by July 2nd, so Wednesday, and then Wallace has till July 7th to answer with 2 more pages as well. So looks like he's thinking hard about dismissing Wallace. I think I've talked before, I think that it might be likely that Wallace gets dismissed from this case. I don't know what happens then with the Texas case, we shall see. But yeah, I think this is showing that Lyman is giving very strong consideration to Wallace's arguments here. So it could come down to just how well they argue this one point. So we'll see what goes on there. The other thing that happened this week was the court second public hearing that we've had on the motion to compel the TAG employees. So a bit of a recap. Lively is seeking to get information from 2 TAG employees, Katie Case and Brianna Kozlow. Now, the allegation here is that they were working for TAG during the smear campaign. They're involved in a lot of the communications. We talked about that last week. And they have kind of rejected this. They've said that we're not involved, we think this is too broad. There was a whole back and forth, and it went to this motion to compel. And the judge said, hey, let's all get on a call, let's talk about this. Now, this call was only between the TAG employees and Blake Lively's lawyers. So Wayfarer were not involved, though he did talk about a number of parties' counsels were on the phone. So I think they were probably listening in, which, of course, right, you're an interested party to this. You probably want to hear how things go in the arguments go. Sophie says, yes, I'm drinking white wine with olives now while Brent drinks his coffee. Well, cheers. See, I'll just mute when I take a sip of coffee. Then that way you don't hear those horrible noises. All right. So you're not allowed to record the hearing. So I can't play you any of the hearing. I can't really tell you everything that happened, but I did make notes. So I do have the notes for you. I forgot that I misspelled Kristen Bender's name, so I apologize for that. It's Kristen with an I, not an E. I did do it mostly in my notes. I don't know why on this piece I got it wrong, but I did. So I apologize for getting Kristen's name wrong. Anyway, the judge basically had them recap the arguments as they were in the letters and to pretend that he hadn't read the letters. He had read the letters. I don't know why. It was just an interesting piece to see of him saying, hey, basically make your arguments again from fresh. Don't rely on your letters. Tell me what you need, what you want. So Kristen Bender, on behalf of Blake Lively, basically said, look, these documents are highly relevant. Case and Costler were directly involved in the smear campaign. We have a number of text messages that they were on, right? We showed last week that Katie Case was the one who sent the message about we're starting to see a shift on social media due to Dad Wallace and his team, shifting the narrative and putting a spotlight on Blake and Ryan. Case and Costler were also copied on a number of other communications about the 3 HR complaints about Justin Baldoni inviting a girl up to his hotel room, a rumor. So they're directly involved in the core of the digital campaign. They've reduced the focus of the RFPs. They've only after requests 1, 5, 6, and 7. I don't know if we have them, so I can't remember what those are exactly. And they wanted to limit the search from July 1st, saying that they have no problem agreeing on the start date of July 1st, but they want the date to go all the way through to March 3rd because they allege that the smear campaign continued after her complaint was released and is still ongoing, and so they want to cover that time period. They argued that the burden on Case and Costler was not excessive, especially because they are seeking this information from them. They were happy to allow Wayfarer to provide the other part of it, but Wayfarer haven't provided the other part of it. So at this point, Case and Costler are the only source for a lot of these documents. So it's not excessive to ask them for them because there's nowhere else to go. They did agree to cost share. They talked about if, they would pay for the imaging of their devices. And they also talked about they need the documents because originally it was supposed to be 10 days after the motion to compel, which I think has already passed. So the judge had asked them, when do you need this by now? And they said they would be content to have it by July 7th because they have not fully started their deposition schedule yet. They said they were going to work it out last week. They had not yet sent notice of deposition towards Case and Costler, but they do have depositions lined up for 9th of July. We don't know who or what, but they wanted these documents on July 7th so that they would have time to review them so that they could be used in those July 9th depositions. So on the other side, we have Maxwell Breed, who is the counsel for Katie Case and Brianna Kozlow. He kind of repeated his argument that, Lively reducing the scope already admits that the original subpoena was too broad, and that Case and Costler were passive participants, that they weren't involved in a single communication, which we know is not true. He also wanted the dates to be limited from July 1st to December 21st, arguing that Katie Case is no longer an employee of TAG and hasn't been since December. When asked when, he said he doesn't know and can't remember the exact date, but would submit a letter to the court to clarify. That seems crazy to me. As a lawyer, if you are in this case and you are representing this person, and at the core of what they're being accused of is their employment at this company, you don't remember what date they were terminated or what date they left. I shouldn't say terminated. We don't know what happened. I suspect that the date was after December 21st, and so he didn't want to admit that because that would already weaken his argument for December 21st. That's why he's like, oh, it was sometime in December. He also argued that as far as Brianna Butler Kozlow is concerned, the date is fine there because even though she's still employed at TAG, the work by TAG was they were retained in August, but had completed the majority of their work by September. That doesn't seem to track with what we already know either. And his main point was that he wanted group text excluded, right? That he really didn't want to have the extra burden of reviewing all of these messages and including group text and sending them as well. But to me, that was a weak argument because it's exactly the opposite. If you're going to exclude group text, now you have to take all of your messages and you have to hand review to find out which ones are single party and which ones are group text. So you're actually increasing the burden and cost by having to filter those out. Now, Lively's team did make an interesting point about the group text, saying that, look, we need the group text because the way that PR conducts themselves, especially crisis PR, is most of the work that they do is done via group text. And if you look at a lot of the evidence we've seen, the evidence is that most of these text messages and emails are to multiple people. There are very few communications that are single party. They're just, between two people, or I should say two-party communications between two people. Very few of those text messages are. So Lively's saying, look, if you grant that the group text messages are excluded, the vast majority of the information that we are seeking would then be excluded. So, yeah, and then they went on to talk about the cost sharing, and they did again make the point that Lively had already agreed to share some of the cost burden, and that if he did compel, that she would be able to do it. So most of this is review of what we already know. There was not a lot of new information. There was, however, one really important piece of new information that this hearing brought up. So I'm going to share that with you. So as part of arguing about the dates, the judge asked Breed to remind him of when was case terminated and all the rest of the stuff. And so he's like, okay. And he asked Kristen Bender, about the date being extended to past December, why it should be extended past December. And Bender brought up the fact that just the prior week, Judge Lyman had made a decision in terms of the motion to compel Wayfarer for the emails and content creators and journalists that they talked to, saying that it was not irrelevant for them to extend past December because Lively has alleged the campaign is still ongoing. So it was perfectly fine and in scope and relevant for her to seek communications past December. So Bender made the case of, you've already set the precedent last week with your decision on the Wayfarer case that we're totally fine seeking documents past December because of the ongoing smear campaign. But then Lyman kind of pressed her further and said, Miss Bender, do you have any information that TAG was working for Wayfarer parties beyond the end of December? Now, remember, Breed had talked about their contract and retention had been up in September. Bender said, one piece of information that I can think of at present is that Miss Kozlow, Brianna Kozlow, who still works for TAG, at least, appears on a privilege log in connection with Skyline. Skyline is an entity that apparently was retained to post documents about the Exhibit A by the Wayfarer parties. Skyline is a new name to us. We don't know who they are, and I don't know what they did. I don't know if what she means by post documents is that they were involved in the production of the timeline of relevant events, which is Exhibit A, or the lawsuit info website, and they were posting the documents to the website, or whether what's being said here is that Skyline was some sort of company that was engaged to make social media posts or post articles about the lawsuit info and the Exhibit A timeline of recent events. We don't know. What we know is that they have apparently tried to subpoena information from Skyline, and Skyline have, given, or somebody has given a privilege log about Skyline's information that also includes Kozlow, showing that TAG was actively still working with Wayfarer or with Lyman, Liner, Friedman, Talman and Cooley, the law firm that represents them, because they were the ones that produced the website, well into January and February. So it'll be interesting to see if we get any more information about Skyline. I can tell you this, as soon as that call ended, there was a sound of everybody hitting their keyboards, Googling Skyline to try and find this company. I don't know that anybody has found the particular Skyline. There is a lot of companies with that name. So I think that will probably be part of the public hunt from now on, is to find out what we can find out about Skyline and their connection to TAG, to Wayfarer, and to Friedman's law firm. So yes, So apparently they do have a lot of information that we have not seen that is not public yet, which we expect as they go through discovery. Much of it is not going to be public. But it, again, continues to connect them all to this ongoing digital smear campaign that has continued, not just while the film was coming out in August, but also even after the lawsuit came out. That was their default mode, was to continue to carry on this this digital combat plan and go after Blake Lively's reputation. And it seems that the litigation strategy was part of that as well. So this could spell some big trouble for Friedman's law firm. So the judge gave his ruling. The motion to compel was granted without the modifications that Breed was asking for. So it is the original subpoenas that production that they had asked for from Lively. So what that means is it will still just be the handful of requests that they said that we're willing to accept, 1, 5, 6, and 7. It will, however, include group communications. It includes all documents involving Baldoni, Heath, Sarowitz, and Abel, but not just limited to those. The time period is the time period that Lively wanted, from July to March. Found that reasonable due to the alleged ongoing misconduct, and that there would be cost sharing. And in the call, he pointed to, oh, it's the cost sharing as outlined in the email, bullet point 2, page 8. Like, so I've just copied what was in the email here to make it a little clearer. Basically, that Lively agreed to cover the costs of the vendor, Lighthouse Discover, eDiscovery, imaging their devices, basically, and hosting the data for the duration of the actions. For the avoidance of doubt, except for payment, the collection process and the database will be independent from Lively, any affiliate parties, and the council, and only the following will have access: Miss Case, Miss Coslow, their counsel, and the Lighthouse staff that is ethically walled from any other work. They'll then do the review before they are produced over to Lively, and the production deadline is going to be July 7th, 2025. So Lively will have those materials from Case and Coslow going into the depositions. So she is going to have more of those text messages around those HR complaints and any other Jed Wallace stuff going into those depositions, which is going to be really useful for her side going into those depositions. The judge rejected the claims that Case and Coslow's roles were minimal, and as they wrapped up the hearing, I don't know that I have notes on exactly what was said. Let me just see if I can bring it up and see if I can find it while I'm talking. But Breed, basically, as they were like just wrapping up, Breed had to get in and make a final point. As they're wrapping up, he's like, "Do you need anything else?" No, he's fine. He said, oh, he'd argued that he didn't know why his clients were involved because they haven't had deposition notices. So, how could they be involved in all of this if they haven't got deposition notices? And it's funny because, like, earlier in the call, Lively's lawyers had said, like, we haven't yet done our full deposition schedule, and we're working on that in like the next day or two. So but it's never a good thing when you're wrapping up the call and he's like, but there's one thing I would like to say on record, and you're like, oh god, just give it up, man. Yeah, Breed was very he was not as confident a speaker. I don't necessarily know about his arguments, but I will say, just as a confident speaker, public speaker, he did not seem very confident. I don't know if that was he didn't have that information to hand and wasn't well prepared, or he's just not a good public speaker. But that's not great if you're a lawyer. But he struggled a lot. Lots of struggle there. All right, so that's what we got there. What did it? I kind of missed and jumped around a bit. All right, so let's go through the other pieces that we have this week. We had talked about Matthew Mitchell last week, another Johns Works employee that had been involved. They had filed to be able to subpoena him. Well, he has now been subpoenaed by LinkedIn. They sent the message to him, and he has been subpoenaed by LinkedIn. So there you go. I'm going to catch up with chat a little bit. Let's see. Sophie says she's got dealing with a heat wave. I apologize. I'm sorry for that. Living in Texas, though, I do have to question, like, what do you call a heat wave? Monkey says, I'm glad to get such a clear recap of the hearing. I was trying to follow it in chat, and it all got just a little jumbled in my head. Yeah. again, like I say, I wish we could do something more more detailed about it, but we're not allowed to record it, so you have to deal with my hand scratched notes. I got most of it down, and I did make a like my version of a transcript out of it, but I don't think it's got everything, and I don't really want to share it. I'm sure there'll be an official transcript or something. Um, uh, Kira says, Mukam, listening to the hearing was fun and definitely a new experience, but I have to confess, I missed a lot of what was being said, so it's great to have a recap. Yeah, I will say the first hearing that they had on the protective order felt a little easier to follow. I felt like Judge Lyman interrupted quite a lot, right? And he's allowed to, he's the judge, but I do feel like he had points he wanted, and so he kept having to, like on both sides with Bender and Breed, have to kind of like get them on task rather than getting them grandstanding. So Sophie says, if Lively says she'll pay costs and Wayfarer will required to pay her legal costs, will Wayfarer end up paying for it? That's a good question, but yes, possibly. Because it's costs and fees. So that might be considered one of the costs and fees that she had to incur as part of this. Yeah, in a way, Blake Lively's trying to spend Wayfarer's money if she gets those costs. Kim says, sometimes you should remain silent. His last comment didn't make anything better. No, it sounded very petulant. It was not good. I think he was surprised by the contradiction between his client's claims and Bender's claims about their involvement in escape. Yeah, I don't think he was expecting to hear about the Skyline stuff. And I think that threw him off because obviously him claiming that they were done in September and then her turning around and saying, no, she's on a privilege log from, at least June, January, February. It absolutely blows his arguments out of the water. So I don't know if he did not know or if he was just trying to mislead the court and not give that information out. I don't know. Don't know enough about that, him or that law firm. My lady says, I enjoy Lyman's straightforward approach. I'm the type who prefers meetings to stay on topic. Oh, so there was one entertaining bit. I forgot that bit. During the hearing, Breed had like an echo on his side, I guess, whatever thing he was using. And Judge Lyman had to like jump in and say, you've got an echo. And Breed had talked about like, oh, I'll have to talk to my IT team about why that is. And so as he was wrapping up for recess to make his decision, he had to tell them all. He's like, all right, I'm gonna go for a brief recess, but I'm gonna put everybody on mute, and that means so if you're not muted and you speak, I'll be able to hear you. So please mute yourselves. And so it's like he's having to explain how the mute button works, which is interesting because at the beginning of the call, I guess they had not muted everybody on the call, and there was a bunch of people joining the call, the public, and so it was just the Wild West with hearing people shouting, talking to co-workers. Yeah, it was crazy. I think there was one person at some point commented like, "What kind of bear is this?" Was stuck in my head. I was like, this is wild. This is insane. They eventually figured out how to mute everybody though, other than the people who actually needed to speak. But it was the Wild West for the first couple of minutes. Oh, fun times. All right. So yes. So Matthew Mitchell's been served his subpoena. I mean, at this point, I don't know how much information they're going to get out of him. Like, if he's not responding to anything and can't be served, I don't necessarily know they're going to get any information from him. He might just try to duck his subpoena. So I don't know. We talked about the Jed Wallace file things. Tara Hanks. Okay, so we also got a decision over on the Wayfarer third parties. Lively had been trying to compel the Wayfarer third parties. I think they'd asked for materials and subpoenaed them back in March, maybe February. And these are, we talked about it, these are the 8 Wayfarer people, the executives and their assistants. Let me bring up my slide. There we go. So for reference, these are the people that she was trying to subpoena, and it got bounced down to district court instead. So I believe Dion Suleiman is Georgia, so it was everybody but Dion here was subpoenaed over in California District Court instead. So the president of Wayfarer, president and co-founder, VP of Head of Marketing and Comms, and the VP of Operations. The assistants to Mr. Heath and Baldoni that were on It Ends With Us, and then the life coach, or the health coach that Justin had kind of recommended to Lively as well, had all been subpoenaed in there. And so the judge basically comes back and says, look, there's not really any actual dispute here about the subpoenas. You're not arguing about the contents. You're not arguing about the relevance of the information. Really, then, the only thing that Lively's seeking to compel is just expedite the process. She disapproves of how long it's been taken and actually to complete their production in a timely manner, and she wants action 10 days from now. If you remember, they originally said that they wanted a deadline of April, which Lively granted. They missed that deadline. They said that they would produce shortly in June. They missed that deadline. Then they said they would produce June 27th. I don't know whether that happened, but they would definitely hit the deadline of July 1st for substantial completion of discovery, of document discovery. So the judge basically says, she's wanting to accelerate that. But he points out that 10 days would be exactly when they are saying that they would be done on July 1st. So given the facts outlined, there's no ripe discovery dispute requiring judicial intervention. So I don't need to argue about, whether the subpoenas are broad and, overbroad, or whether they're valid and the information being requested is relevant. Like, you all seem to agree. And the motion to compel is otherwise going to be moot within days. So I'm going to deny the motion to compel in the extent that it seeks to accelerate the documents before July 1st. But it is granted to the extent that it seeks to compel completion by no later than July 1st. So this is bad news for Wayfarer, because now they have to hit that July 1st deadline. If they're telling the truth and they have been trying to collect this information, and we're going to do a rolling production from June 27th to July 1st, shouldn't be a problem. If their intent was to hit and miss another deadline, this is a problem, because that was only 4 days, and now they have to produce everything by July 1st. The judge does say that he would permit them to do a rolling production after July 1st, but only so much as Lively agrees. And that if they cannot agree on the rolling production schedule, then the deadline will just be everything by July 1st. I don't think Lively's going to agree to a rolling production. So it means that Wayfarer now have like 2 days to produce everything for these third parties. Again, good news for Lively, because that means that she will have that information heading into depositions, and the more information she is armed with going into depositions, the better those will be. So definitely a win for Lively, even though the judge did not accelerate it. He is putting a hard deadline on that July 1st and basically taking Wayfarer at their word of saying, okay, you've had other deadlines that you blew through. We're going to take this one as the final deadline, and you best hit it. So we'll see how Tuesday goes, or we'll see if there's a new filing on the docket. I just get coffee. All right, Kim says the most important part of this ruling is the July 1st enforcement. If they don't, summary judgment is going to be easy for them. Exactly. I've seen a lot of like the Baldoni commentators kind of like lauding this up and seeing this as celebrating it, of like, oh, Lively didn't get what she wants, they're going to do what Wayfarer said. But they're missing the fact that this has now gone from a suggestion of July 1st to a hard court-imposed deadline, which means huge problems for them if they miss it. My lady says, I hope motions for fees. Well, you're in for good news when we get to the end of today. You're in for good news. So yes. So I think that's everything on that side. So we also had more information about Kozlow and Case. I kind of messed up here. I was trying to do that earlier in the runtime and then do the tag employees. So we're going to go bounce back to the tag employees now, because I got things out of whack. This is why I shouldn't be doing these on a Sunday morning. I need time to come round. I also shouldn't be doing this fresh off like a whole week of intense work, because yes, I need some downtime. I will hope to get to it this afternoon. But anyway, another piece that we found out this week is that Jones, we talked, I think I think it was maybe last week, or it might have been like a couple of weeks ago, we talked about that Stephanie Jones had issued a number of subpoenas for social media companies and technology companies to kind of hunt down the person behind the Stephanie Jones leaks stuff, right? The YouTube, the Gab social media post, and the Facebook account. So we learned a little bit more about that this week, and it's not good. So JonesWorks filed subpoenas to Facebook and to Pinterest, I think is the other one she's big fighting, and basically asking them for all of the information about, hey, I'd like to know who the user and everybody is behind this account. They came back, where is, I might have to just, Meta basically came back and said, oh, let me go. Is this not it? Am I looking at petition Stephanie Jones motion to compel? Oh no, this is the actual motion to compel, I guess. I'm getting the wrong piece. I don't see the objection. Is it this one? Oh, it is just this. No? I guess I didn't download it correctly. All right, I'll have to go grab it in a second. But basically, she's filing a motion to compel, and I'm not going to go through it because, I mean, it's fairly obvious. The accounts and Facebook and Pinterest accounts of those people that are posting this stuff behind her. So she served a subpoena to Facebook, but they objected. And I'm going to have to give me just 1 second to go get that pulled up. Is this right? Jones versus Abel? Yeah. Need the wrong one. Jones versus Meta. And I remember, like I said, we talked about this a couple of weeks ago because MJ Morley, I've talked about a lot. We'll continue to talk about. Fantastic content creator, brings really good legal analysis. Definitely go follow her if you are not already. Had kind of found a bunch of these other subpoenas to tech firms, and so they had talked about like, oh, she's going after all of this stuff. I think, no, this is it. This is it. Request for production, and then there's no objection. All right, I'm trying to find it. It says that it's the objection. Just take a moment amongst yourselves to figure it out while I find it. There it is. Exhibit 3. My bad. All right, guys. Finally got it. Finally got it. So Meta responded and basically just said, hey, before you come to us, you have to try and find the person involved in the first place. And then you have to show us that like there's a good belief that like basically there's harm done to you and that this is relevant and you're not just fishing, and like you have to show us that, that you have to get that information from us, basically, like, the rest of the stuff. Cool, fine. So she's arguing for this motion to compel to say, hey, I have a vested interest. I'm making this this complaint. I need this information to go after the people who are, trying to defame me and putting this information out there. That by itself, very simple, straightforward. Where this gets really interesting is that Facebook were not the only ones to oppose this. There was also a letter from Pryor Cashman. Pryor Cashman is the law firm that is representing Katie Case and Brianna Butler Kozlow that we just talked about with Tag. They came back and filed with Jones to say, we're in receipt of your subpoenas to network utilities, WhatsApp, Signal, Meta, blah, blah, blah. Based on our review of these subpoenas, they solicit private and personal identifying information of our clients. As a result, we object to the subpoenas. What? Why? Why do they call for a production of your client's personal data? We're just after the person who's behind those accounts. It is insane to me that basically counsel for Katie Case and Brianna Kozlow has decided to basically stand up and say, oh, we don't think you should have that information about who runs those accounts because it would expose my client's private details. Gosh, I wonder who could be behind those accounts then. Guys, it's a mystery. So I guess we are getting closer to who was behind all of the websites and smear campaign against Stephanie Jones, and it does appear to be those two TAG employees, basically by duty of the fact that like her lawyers are coming up and saying we object to those third parties subpoenas. They also objected to the subpoenas directed at ATT, Google, Pinterest, and Verizon for the same information. Again, we object to the subpoenas because they call for our clients' personal data. Just basically openly upping and admitting that they are involved. This then, of course, makes it very easy for her then to subpoena those two, I guess, for their relevant information instead, or go around them. But I don't know how likely her motion to compel is going to be. I will say I get the feeling that getting information out of those social media companies generally is pretty hard. Also, given the fact that they are tech companies with really powerful, expensive lawyers, that probably also makes it very difficult to get information out of them. Prior Cashman, however, seemed to be absolutely terrible. So you might have better luck going after them based off these two and say, cool, we'd like to know every single social media account you've made that's about Stephanie Jones. Thank you very much. Kira says that's the biggest self-help goal. Yeah, I mean, at this point, I don't know how anybody on Baldoni's side tries to continue to say there was no smear campaign and nobody was involved when we have basically TAG's own lawyers openly admitting that, yes, we were actively smearing Stephanie Jones. But of course, they were only smearing Stephanie Jones. That is the only person they were smearing. They only had this extensive social media campaign to take down Stephanie Jones. At no point did that firm also have a digital campaign against Blake Lively. That would be ridiculous and unbelievable. It is so wild to me as we continue to go through this, just how much the wheels are completely falling off Wayfarer's case, and yet there are still devotees out there preaching the gospel of Baldoni, preaching Saint Baldoni, you know, and you're like, how are you even following the case? I mean, this whole thing started, right, because I would get so many people in my comments saying, you're not reading the documents, you haven't kept up with the case, you haven't read the documents. And I had somebody today saying, well, Blake Lively hasn't presented any receipts. And I'm like, are you following the case? This man's entire case got tossed because he did not bring receipts, didn't even conjure up a valid, legal, actionable claim. How are we still on the talking point that Lively doesn't have receipts? She has so many receipts, she's going to trial. Baldoni didn't bring enough receipts to even get to trial. Like, how are we still doing this? So yeah, I think they've all given up reading the documents at this point because the documents are incredibly damning, especially this. This seems, like you say, such an own goal. Kira says now Jones can go after Kozlow and Case, right? I mean, that seems to be it to me. I mean, if their law firm wants to self-identify and say, hey, that would take our personal data, it seems to me to be fair game for them to subpoena them for the information that she's looking for. Yeah, Kira says, I think this leads to Doe 1 to 2 being these two tag people. Yep, I agree too. My lady says, I'm so sick of people saying nonsense without having read anything themselves, but Baldoni didn't even try to dismiss any of her claims because he knew it would be embarrassing. Yeah. I cannot handle more people telling me he has a receipt she doesn't in the comments. That level of delusion is crazy, says Bill. I know. I've just stopped. I mean, it's... you can't argue with people who are refusing to accept facts. So yes, so we'll see how that goes, but at least now I guess we have an answer as to who did that. But that's obviously pretty bad for TAG. Where that becomes interesting, of course, is that most of, I think, this stuff was before TAG was connected to Wayfarer, right? They were officially retained August 2nd is what was in the legal documents. So if that's the case, then why was TAG going after Stephanie Jones beforehand? I think it speaks to something I've talked about before, which was there was a text message from Abel in Stephanie Jones's complaint where she talks back in May. Somebody tells her, I think Melissa Nathan is two-faced. And she says, you think? And I was like, if they didn't retain TAG until August, why is Abel talking about Melissa Nathan in May? That to me speaks to a much earlier involvement and connection. There was some connection point here. There's some reason that Melissa Nathan kind of came up there. And so, yeah, I think that's going to be interesting. I think this opens the door for a lot more involvement of them, and I think it's interesting that we have an answer now of who it is. Now, are there more people involved at TAG? We shall see. Milady says, yeah, all the receipts are with her, 100%. Muckamuck says, an empty motion to dismiss could have knocked off a couple of... They could have just knocked off Sarowitz. I don't understand that. I mean, Sarowitz seems very easy to have got dismissed as not really being involved. So why they didn't bother to just try and get him out of the case, I don't know. I don't know. I'm also very sneezy since turning back home as well. So that's all of that. Let's see what we got. All right, so now we'll bounce over to continuing this whole social media campaign nonsense to Liner, Friedman, Tattleman, and Cooley, who, what was this conference? What is this? Oh, yeah, so there's going to be a conference. Okay. So let's go talk about this. Liner, Friedman, Tattleman, and Cooley. You have to give me a second because I am like struggling here for a second. Supplemental from Lively, supplemental from Liner. We got this right? Okay. What did I bring the subpoena up for? Don't know. We'll get there. I'll collect my thoughts and we'll get this right. All right, so Lively filed a supplemental motion as part of the motion to compel Liner, Friedman, Tattleman, and Cooley for their contact with social media content creators. They filed it, and they are kind of backing up their case as to why they should get them. If you remember, they argue that Friedman is a witness and a party to all of this stuff that's going on, and they want their communications with content creators to the extent that they've used content creators and brought them on as part of their legal strategy. Liner has said, well, we did it so because it's part of our litigation strategy, and so that should be protected and privileged information. Lively says, no, you hiring content creators is not you giving legal advice, and so therefore it's not protected. And that's what we're kind of coming in through here. I don't know where this piece is. I guess it's page 1. Okay. So she's talking about it, and they bring up a lot of the rulings that are already happening, and especially on the Wayfarer parties losing their motion to compel against, content creators and stuff. So this is providing her a win because they brought it up in the TAG hearing, and now they're bringing up here against Liner, saying that the Southern District of New York recently issued multiple discovery rulings, including on third-party subpoenas relating to requests bearing on digital creators. And all of which are squarely relevant. So they're basically saying, look, this is being held in a California court instead. She wants it transferred to New York under Judge Lyman, but to the extent that it isn't, she's trying to very much show what is happening in that court as a kind of, so therefore you should see and have this context and align with that court and rule in the same way, essentially. Talks about here, these considerations outweigh Liner's interest in obtaining local resolution, so it should be pushed back up into New York. As noted, Liner is presently litigating in New York, has entered appearances in office there, and yet chose to bring claims here. And that the Southern District is resolving disputes remotely, so there's not any burden on transferring it to the court. In terms of quashing it, though, she points out here that Liner's primary arguments that requests are definitionally overbroad, burdensome, and target potentially privileged information have now been rejected by the recent court order. With respect to Liner's overbreadth and burden, since the instant motion was filed, the District of New York has ruled that content creators, is a perfectly fine definition. They tried to argue in this case the same as they did in New York, that it was vague and hopeless, too broad. Well, she's now citing the Judge Lyman's decision against Wayfarer about content creators, saying, actually, he's already decided in that case, not only is it not broad, too broad and burdensome, but you know, we're only after a subset of them, those who do so on the behalf of Wayfarer Party and engage with them. And it's the same here. She's only asking for ones that do so on the behalf of Liner, Friedman, Tettleman, and Cooley. LFTC. We're just going to go with LFTC. So yeah, also that, you know, it is particularly specified. They can actually bring a response. As to the issue of privilege, it cannot reasonably argue that agreements, invoices, payments, and financial information are privileged. And that, as she previously addressed, the content creator requests seek information from Liner and its lead counsel that relates to a non-legal witness and spokesperson function, not a legal one. I think we're good here. And in particular, they bring up the fact that Friedman went on Megyn Kelly, and then talks about where, you know, there was an organic response as a result of that. I think it was too much for her. I think it was too much for her to believe that somebody would actually not like her based on her own conduct. I think that's something that she couldn't handle, whether, you know, that's an interesting narcissism quality or otherwise. This is clearly not protected, right? As a lawyer giving, you know, press speeches, he's not talking about the case. He's not talking about details of it. He is now making accusations and defaming her by calling her a narcissist. And then goes on to say, you know, I'm not a doctor. Then why are you calling her a narcissist? Again, as a lawyer, this is really bad conduct. And so she's being able to use his words against it, because as I've talked about, statements to the press given by a lawyer can be used in court. So be very, very, very careful about what you say. Friedman is not, and so he should fully expect his words to come back to haunt him. And, you know, she also made the point that we made when I read this out, that they're objecting to these requests because they're not crucial to Lively's harassment and emotional distress claims, but that then accepts the argument that they are critical to her other claims, her retaliation claims. Like, I don't know why you would have made that. They also continue to make that in their response here multiple times. Where are we? And if we're any doubt as to about this motion to compel, New York has made clear that third-party communications such as those sought here are patently relevant. According to that court, Lively complaint states that defendants themselves continue to be involved after December 21st, and thus found that Wayfarer's Party engagements with the media outlets after the release of the CRD complaint is relevant to the truth or falsity of these claims. Again, using Limer's decision to back up here in this other court. Think it's pretty compelling. Did you think it's pretty interesting? So yeah, pretty good stuff. Liner then have also filed a supplement to it. I'm not as impressed with this one. We'll see if you agree or not. I think Brett said he wasn't covering Brett stuff, but he touched on it last week. I will be covering Brett stuff this week. Oh, I will be covering Brett stuff this week. Did I miss it? Did I have it at the end? Where did I have Brett stuff in here? I didn't have Brett stuff in here. I did not forget. I forgot to put it in here, but I've got it. I will cover Brett stuff here. As I've talked about, I'm not covering Brett's motions at all. If you want to, they're on the docket. Go read them. Brett McDowell also has a Twitter, which has a lot of his stuff in there. There's a ton of content. If you're willing to engage in it, you want to, and you're interested, I am not preventing you from doing it. I am not going to talk about it. I will talk about one of his filings from this week, though. And I'm going to interrupt the middle of this this one to do it, because, oh my goodness, it is probably the single best filing that we have had in this entire case. And yes, I am extremely animated and giddy because Brett decided to file a motion to the Southern District of New York to let them know that a mechanical failure in the HVAC system of the, quote, building where filings are being prepared has materially affected the working conditions over the past several days. Important to note here, Brett is pro se. He's representing himself. So the building where filings are being prepared is presumably his house. He's telling the judge that he's having air conditioning problems. The failure is likely related to recent air quality issues in Winnipeg, which may have compromised the air handling systems. In addition, availability of HVAC replacement parts has been limited due to regional demand and ongoing supply chains, resulting in continued disruption. This does not excuse any drafting oversight. These conditions have significantly impacted Movement's ability to work consistently and comfortably during critical filing periods. you've been told your motion to intervene has been dismissed. You've been told you have no interest in this case. There's no critical filing period. You're not involved. A clarification regarding a previously submitted filing is being submitted currently in good faith. The other filing that he filed was that he'd incorrectly stated that Doug Lyman was in a simple favor, and so he filed this important correction that Doug Lyman was not, in fact, involved in a simple favor, which, okay, I don't know why not having air conditioning has, delayed that critical fact from being submitted, but if you're wondering why I don't cover Brett McDowell's filings onto the Blake Lively case, this is why. This is the most coherent filing, I believe. Hilarious. I love that we have this in the record. So I will say, in this one instance, I thank for this gift, because this was amazing. Hey judge, my AC is not working and I'm not getting parts. So, but I will say, I feel sorry for Brett. Apologize for your lack of working AC. That is a miserable condition to be in. I hope that gets resolved soon. I look forward to seeing the update of when you're able to get somebody to work on it. Let me know how things are going with the dishwasher and the refrigerator as well, because obviously I'm very concerned about all of the appliances up there in Winnipeg and what else those air quality issues are going to affect. But hopefully we'll continue to get updates. So yeah, that is the only filing from him that I will be covering though. So go enjoy that one. That was amazing. All right. Back to Liner's response to the motion to quash. They say that, Lively thinks she's entitled to discovery because it acted as the way agent of its clients. First, all litigation counsel are agents for their clients. She's asking for information about content creators. I don't think that Liner can reasonably assert that they are agents for every single content creator that they have contacted. They go on to say, simply because a lawyer advocates for his client, even reported by the press, does not entitle opposing parties to discovery of that lawyer's files. It does if those statements to the press are not strictly about the case and are part of a continued defamation and smear campaign against her. They say that hypothetical relevance does not rise to the level of crucial, but again, Liner have themselves admitted that they possibly may have engaged content creators as part of their litigation strategy, which would then make them extremely relevant, especially to her claims of an ongoing smear campaign and retaliation campaign against her. I don't necessarily know about the case law. I did not get time to look up the case law. I will say, when I've read the case law before, their case law has been pretty weak, but we'll grant them that, yeah, maybe they're right that Lively's case law is weak here, and we'll have to wait for the judge to decide on that to see, because I did not have enough time to kind of go through today. I missed the piece that I'm looking for. Gosh, what are we after? I guess I missed that. Oh, it's because I'm on the wrong one. I'm still looking at Lively's. Page 4 was where we were headed. So let's go to page 4. Lively does not contend that LFTC is a part of Wayfair's business operations, or that it has firmly injected itself into the litigation as an expert through factual declarations. Rather, Lively contends she's entitled to obtain documents because it was a witness and agent for its clients in an alleged smear campaign. As evidence, Lively points to LFTC partner Brian Friedman's prior representation of celebrity clients and public statements to the press as the Wayfair party's lawyer. Surely, Lively does not contend that statements to the press entitled her to broad access to LFTC's files. No, that's not what she's saying at all. We're saying that that is part of your ongoing smear campaign, and you were talking to content creators. Why? Why were you talking to content creators? And that's what we're trying to find out. They then go say, well, she should be able to obtain the information from the content creators themselves. Okay, who were the content creators? Sure, let's go get the information from the content creators. You just tell me which of the content creators I should go get the information from, and then we can go do that. This is a wild argument, right? Because obviously she does not know who the content creators are, so she cannot go obtain it from the content creators. I'm sure Lively would be more than happy to go obtain it from the content creators instead if Liner were to provide a list, but they've objected to providing a list. So they are the only people who can give it to. They then go on to say it encompasses privileged information, that, you know, because those accounts were also used for other purposes, they shouldn't have to reveal if they were used for paying content creators, which don't necessarily agree with, but I don't know. We'll see what the judge says. I'm not a lawyer. And then they don't want this to be transferred to the Southern District of New York. Of course they don't, because they believe Lyman's had enough of their crap and they've lost a lot of these motions to compels, and so they will probably lose this quash. They go on to say that, you know, well, it has to be that transfer has to be because of there would be an inconsistent outcome here versus New York or all the rest of it. Actually, it's also like about burden as well. I think Lively made a good case about the burden transfer. So they're literally kind of trying to say, well, no, it should be held here. This court can and should decide this motion. Lively argues that the LLC has the ability to litigate in New York as evidenced by it, but they say Friedman's comments, right, from the February hearing about, hey, I want to consolidate everything in this court, well, were only about her allegations of sexual harassment. Again, they're trying to narrow it to she's only making claims of sexual harassment. She's not. She's got 13 now claims, right, in that court. Not all of them are sexual harassment. Some of them are about retaliation, and all of this information is directly relevant to the retaliation claims. Lively's sexual harassment claim is not implicated by the subpoena at issue, but we've already clarified it's not about sexual harassment. The fact that Liner continued to ignore the other claims and focus in on this is not great for them. I don't think it shows that it's a very compelling argument, but we will see. Did I miss a footnote? Page 5. Oh, here we go. Lively wrongly claims that LFTC could only be a witness prior to the filing of the complaint rather than opposing counsel. While LFTC may not have been counsel of record, it certainly could have been providing legal advice that would be protected by attorney-client privilege. And that is true. It could have been. If that was the case, why, right? Lively had not filed her CRD complaint. And as Wayfair at the time had mentioned, they had no idea the CRD complaint was coming. It took them completely by surprise. Blindsided is the word they used. So what were they retaining Friedman for before then? I suspect it was because they were planning to go after Lively, and we know they were also planning to go after WME. The question is more whether those conversations involving Friedman back in mid-August were about providing that legal advice and kind of preparation for litigation they expected were going to come, or whether he was doing what we're talking about here, talking to content creators and trying to prep his smear campaign that seemed to follow every time anybody comes up against Friedman. So interesting, and we shall see. They then go on to say the other reason why it shouldn't be litigated in New York is because, well, yeah, sure, we have a business interest in New York. Nobody works out of the New York office, which is so weak because, again, if you're registered to do business in that in that state and you have an office in that state, it shows you have a vested interest in that state. But they're like, yeah, nobody works out of that office. Again, own goals for days from these guys. The other interesting thing about the LFTC motion quash over there in California is Lively's added 2 new attorneys that are from her law firm, Manat. Is it Manat or Wilkie? I forget. I think it's from Manat. Stephanie Roser, and then also Sarah Moses. And no disrespect to Stephanie, sure she's a really good lawyer, but I'm going to just focus on Sarah because Sarah has extensive experience in dealing with this sort of cases. She also has experience dealing with RICO claims because, if you come down to the bottom, she talks about she represented a prominent U.S. attorney in his law firm in connection with a civil RICO case, and state law claims brought by an actress concerning firm's representation of Harvey Weinstein. She she represented Rose McGowan in her case against Harvey Weinstein. So that should make Baldoni and Wayfarer very nervous. This is somebody with experience in this area. Now, the claims against Harvey Weinstein were eventually dismissed and were not strong enough. I don't know how much. Sarah was one of a number of lawyers on that team on that case, so I don't know how much of it was down to her. But I think she will be definitely very, very excited. Well, I guess excited might not be the word. Very eager to have another crack at going after a predatory man facing these sorts of allegations and trying to uncover the conspiracy of silence around trying to silence his victims. So again, this all kind of reinforces that there's a much broader conversation here than just Baldoni and Lively, and that this is about society generally and our attitudes towards victims who come forward to talk about sexual assault and sexual harassment. And they are continuing to build this case of really good, intelligent, smart people who are well versed with experience in this. Meanwhile, Baldoni is still continuing to be represented by a man who throws fists when he does not like and get his way. So, I mean, take from that what you will. Yep. So let's see what else we got going on in chat. Hypothetically relevant is indeed crucial, says Donald. 2 minutes in and already misstating the law. Could have got it from content creators. Very much instead of sending an email, why don't you try carrier pitching? Yes. Like what do they do? Just send out random subpoenas to content creators everywhere and just hope one of them lands? Spring Violetta says the billable hours spent on this. Oh my gosh. It's going to get worse. We're going to cover the Vanzan piece in a minute, and that is going to be so much worse. Maybe Friedman has not read Blake's complaint, says Kiera, and doesn't know about the retaliation part after December 21st. That's mostly about him. It's pretty much all him. King Gator says the Lively team can't directly subpoena Flaw and other known creators. King, yes, they could, right? The issue is they don't necessarily know that Flaw is one of them. I don't believe that's the case. And I think the other issue as well is I don't remember if Flaw is a resident of this country, and it makes it very easy to duck and avoid subpoenas in other countries and the burden and stuff. So, like, I don't necessarily know. So it makes it very difficult. I also think, like, unless you can actually show evidence beforehand, you can't just randomly subpoena content creators in the hopes that you land, right? That is exactly a fishing expedition and the kind of thing that you shouldn't be using subpoenas for. There needs to be some sort of expectation that the results of the subpoena will generate discoverable information. So you can't just throw subpoenas at people on the hope of maybe, right? Because then they have to incur a cost, hire lawyers, do all of this stuff. And if they've not done anything, if there's no discoverable information that could have ever happened, then, you know, you can then be on the hook for all of that. So they don't necessarily want to just throw subpoenas out everywhere. They need to have an idea. And I think it's more likely going to be very small creators that you find that they've been talking to and are putting stuff out there. But I might be wrong about that. I might be wrong about that. So yeah, in fact, let's jump into that because I'd forgot about that piece as well before we jump into Vanzan, because on that piece of Liner talking to other people, oh my gosh, I did not save the screenshot. All right, so we're gonna have to just bring up my Twitter, and we'll do it from my Twitter. We're doing this live, guys. So you remember how a few weeks ago, Lively argued that she needed all the information from Wayfarer because the allegation was that they were using these dead drops. The idea that they could put information into an email account or something else and drop information to content creators who also had access to that email account. They could pick up this information and then be able to make content on it without directly talking to those creators, right? Well, this week we got more evidence of that possibly happening. Where did I go? Did I forget about it? I guess I did. So here we go. So People magazine published out this statement from Brian Friedman this week. And it was talking about the dismissal and why they didn't file a dismissal and what's going to happen. And they said the court's decision on the motion to dismiss has no effect whatsoever on the truth. There was no harassment nor any smear campaign, and it does not in any way affect our vigorous defense against Ms. Lively's claims, Friedman said in a statement shared with People. Discovery is proceeding, and we are confident that we will prevail against these factually baseless accusations, he continues. Instead of revising the existing claims, our clients will be pursuing legal options that are available to us. Well, they published this statement on June 24th at 5 p.m. Now, I'm going to ask chat as we get into this. Some of you will know what I'm talking about. I'm going to request, please do not mention the creator, right? What we're simply going to say is a creator on a platform who has been putting a lot of pro-Baldoni content out also had this statement. They did a live stream 6 hours before that statement was released to people, and they brought this statement up in, as you can see here, an untitled Google Doc that just says Brian Friedman at the bottom of it. And I'm surprised this is not in Comic Sans. But they had argued that, you know, that Brian had given this statement out and that this is what it was. Now, at the time, everybody thought this person was clearly lying. Clearly, this was fraudulent. Even other Baldoni creators were calling this suspect and clearly a sham because, like, they had just copied and pasted into an untitled Google document and put Brian Friedman's name on it. Like, good job. And then, like I say, what we found out is that 6 hours later, People had the same statement. This seems to be a reveal that yes, Friedman's law firm is indeed in contact with content creators and feeding them, if nothing else, his press statements far earlier than they're feeding them to the press. Now, this content creator tried to argue that they are press and that, you know, they should be included on these press statements. What's wild is if that's the case, if this was a general press statement to a bunch of everybody, why was their first kind of hit on this on media 6 hours later? People were the only one to report it, and they said that they got a statement directly from Brian Friedman on this. Nobody else reported about it for 6 hours. I think, and a lot of us are suspecting, this content creator inadvertently revealed the sort of dead drop situation. Maybe they have only just been included on these dead drops and weren't aware that, like, don't throw up the untitled Google document that we're giving everybody access to on their on your screen. Who knows? Or maybe this is how Brian Friedman has been communicating with content creators for a while. But it is interesting, again, that as we continue to go, these people cannot help themselves in revealing that even as he's talking about, you know, there was no smear campaign, we're seeing that his law firm is distributing his press statements to YouTubers hours before they go to the press. My lady says, this is real? Crazy. Yeah, no. Welcome back says, I totally thought this person had made it up, not that they were own-goaling the dead drop. Yeah, no, you would think so, but no, it's on People's website. It's a statement shared with People. They had it hours before, 6 hours before it went to the media. They had it and were revealing it on live stream. So this is ridiculous. And then, like I said, they've tried to defend it as, well, you know, we're just press as well. They were just sharing it with all press. No. And if it was the case that they shared it with all press, then the other press outlets would have reported it much sooner, right? It doesn't take People 6 hours to write that article. So, yeah, like I say, receipts, right? They don't have any. All right, so where are we going? All right, let's get into Vanzan then. Let's get into Vanzan. The Wayfarer have filed a motion to compel against Vanzan, the known party. If you are coming up to speed of this, when Lively wanted to get the information from Jones, the text messages and everything at the heart of all of this case from Jennifer Abel, a company that she is connected to, Vanzan, filed a subpoena to Jones for those information, and it was sent to Lively, and that became the basis of her CRD complaint. Now, Wayfarer's lawyers have consistently argued, first off, that there was never a subpoena and those documents were handed over completely illegally and all the rest of it. Then it turned out there was a subpoena, and then they said, well, we don't think it's a legit subpoena. And so they have since argued that it is an illegal sham subpoena, shouldn't have been anything. What they've not done is actually filed any complaint about the subpoena or about how the evidence shouldn't be included. What they're now filing for is a motion to compel, saying that Vanzan never handed over the subpoena. They've not handed over the subpoena, nor have they handed over the documents that they got from Jones. And so they are trying to argue in here, saying that, hey, we should get that information. So Abel's claims against Jones Works and its principal Stephanie Jones center on allegations that in August, just prior to Abel's scheduled departure from Jones's employ, Jones seized Abel's cell phone. That's the work phone that Jones owns, and accessed and downloaded the contents. In anticipation of litigation against Abel and other Wayfarer parties, Jones collaborated with Blake Lively to contrive a mechanism for Lively to obtain the data that Jones had pirated from Abel's phone. It's not her phone, it's a work phone owned by Jones Works. I don't know how many times we have to say this. And cloud accounts, including confidential and privileged text messages, which are at the centerpiece of this dispute. This was accomplished through a subpoena issued in a sham action. The Vanzan complaint that they threw up. Abel is informed, then believes that Vanzan is a shell company owned or controlled by Lively and her husband, Ryan Reynolds. The facts speak for themselves. The Vanzan complaint asserted only a bare-bones breach of contract claim, bereft of factual allegations against 10 Doe defendants who, although parties to an alleged breach contract with Vanzan, were never named or served. There is no conceivable link between Abel and Vanzan or the unspecified contract that the Doe defendants allegedly breached. In other words, Vanzan had no discernible need for the information Jones obtained from Abel's cell phone. Again, it's Jones Works' cell phone, but I want to hammer this because this is going to come up later. Their key point is that Vanzan had no discernible need for the information from Jones. They are not connected. There's not any interest or connection to Abel or any of this anyway. There was no reason for them to get that information or for them to request that information. Okay. After the Vanzan subpoena's return date, the Vanzan action was dismissed without any other proceedings and without ever requested the assignment of a judge. Friendly subpoenas are not a crime. I gather, that says Muck and Muck. What are they talking about? Here we are. Kim says this also happened during the false imprisonment. Yes. Oh, TR says, has this creator addressed how they received this statement? You are welcome to go look up on Twitter on my account. They had a meltdown, blocked me. I showed that they had a meltdown. They unblocked me, had a second meltdown, blocked me again. But in that whole mess, they said that they had asked Friedman for a statement, and that's what they had gotten as a statement. Again, this doesn't line up because, again, if that was a statement that he was issuing to press, it would have gone to all of the media outlets at the same time. He wouldn't have had a press statement in response to it that then they just issue out as they're issuing it out. It would have been broadcast, especially to people, TMZ, Daily Mail, their usual media outlets. As soon as they had the press statement ready, it would have gone out to them. That's typically how PR works. You don't sit there and wait to send it out, because the idea that a YouTuber would ask them first and then people 6 hours later would ask, no, it's not. It's either something they put somewhere or broadcast out. I feel they probably did ask for a statement and got that, but I think it's because it was in the drops for the content creators. But we'll see. Maybe I'm completely wrong about that. They were definitely very emotional about me talking about it. Anyway, coming back to the Vanzan subpoena, they talk about Lively produced at least some of the information during discovery. Again, foreshadowing. Hold on to that for a moment. Confirming that the sham Vanzan action was successful in facilitating the transfer of Abel's data to Lively prior to the filing of Lively's claims against Abel and the Wayfarer parties. Again, this is going to be a key thing later on, so hold this in your head. Lively produced at least some of the information during discovery, confirming that the sham Vanzan action was successful in facilitating the transfer of Abel's data to Lively. They talk about Lively's lawyers have defended the Vanzan action and subpoena, that it was common tools that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators. Notice in this motion to compel, there is nothing that says otherwise. They say arguing the ends justify the means, that they admitted the Vanzan action subpoena enabled them to access Abel's messages. Yep. He says such tactics are hardly common or appropriate. Well, hang on. You're arguing such tactics are illegal. Where is that? Where is the law to support that? Now, here in this motion to compel, we've watered that language down to just not common or appropriate, which is a massive step back. But again, it shows how in the press, Wayfair and their lawyers are litigating one way, but when it comes to court, they pull it back. It's that the Doge and Cheems meme where, like, you know, in the press they're all puffed out. This is an illegal sham, and we'll go after them and take every action that we're available in court. And then in court they're like, well, it's not really common or appropriate. Like, okay, it's not legal. Right? The lawsuit is a sham. The subpoena is intended to obtain information irrelevant to the proceeding in which it was issued, and most egregiously, the purpose of the subpoena was to either obtain privileged and confidential information without notice to Abel, or cover up Jones's prior disclosure of Abel's confidential and privileged information to Lively before the subpoena was even served. So part of Abel's allegations is that Jones released some or all of the information to Lively first, then they did the subpoena, then they got the messages a second time, and so part of all of this mess is they're wanting to prove out that information was disclosed before the subpoena. Abel remains in the dark as to whether Jones actually produced documents in response to the Vanzan subpoena, or whether the Vanzan subpoena was merely a smokescreen to conceal Jones' prior disclosure of Abel's information, the conduct at the core of Abel's claims, right? So you're saying she remains in the dark as to whether Jones actually produced documents in response to the Vanzan subpoena. Again, file it away for later. We're going to need it. So now she's subpoenaed Vanzan for documents relating to the subpoena and the release of Abel's stolen information to Lively. They modified them a little bit. I don't think there's much else in here. If my requests are issued. Yeah, where are we? Did I get it on the wrong page? Yeah, I don't think I can find where it's. So yeah, so she argues basically that they've reduced their scope of them. Oh, here we go. The requests are relevant to Abel's allegation that Jones relayed the data from her phone prior to service of the subpoena. And, you know, they're saying they cannot establish a factual basis for undue burden. There's no rule that party sources must be exhausted before calling upon third parties. And it did request the bulk of the documents in March, but Jones has failed to comply so far. Okay. Further still, since Abel is alleging a sham scheme, it's imperative that she obtain documents directly from Vanzan and Jones to confirm what the actual subpoena requested, what was produced, and what communications Vanzan had with Jones about the Vanzan action. Finally, Vanzan's organization and ownership documents are not available from Jones, but only from Vanzan. Okay. So, Vanzan also argues that they object on attorney-client privilege, which seems legit. If they filed, which they did, this lawsuit to investigate the does, right, and find the identity of the people and produce all of this material, then all of this was in anticipation of the litigation that would eventually turn into Blake Lively versus Wayfarer. Now, it seems crazy to me that the argument here is she shouldn't have gone and done this kind of like pre-lawsuit discovery to find out who was involved and how, and that she should have just immediately served Baldoni and Wayfarer without any evidence. And I feel like that is their main issue here, is they want to try to push this narrative that Blake Lively should have filed a lawsuit without any evidence based on speculation, information, and belief, and done it that way rather than the way that we did do it, which was to go find the information from Jones, see who was involved, and then create the CRD complaint with those communications in and to file against them, showing that, hey, there was an actual basis to going after these people. I don't think that that holds water. Like, again, if that was the case, we would be having a very different discussion where Wayfarer would be complaining about, oh, you've lacked any evidence. Why are you filing this baseless claim against them? Because you don't even have evidence at this point. It seems circular and very strange to me. So they filed this to say, we have not got the subpoena. We don't have it. We need it. Give us the subpoena. Lively filed a letter to say, hang on a second. We'd like to interject here. We are not a plaintiff in the Stephanie Jones versus Jennifer Abel case, but we would like to file a letter here because we would like to alert the court to the motion admits critical information that creates a materially misleading record. Specifically, Abel seeks to compel Vanzan to produce, among other things, a copy of the subpoena and the documents that Jones produced in response to the subpoena. What it admits is the fact that Abel and the Wayfarer parties have been in possession of both the subpoena and the documents since May 16th, for well over a month. All of these people who are supporting Baldoni, who've been saying, oh, once he gets his hands on that subpoena, oh, he's going to file all these lawsuits, he's going to destroy her, it's going to be shown it's an illegal scam. He's sat on that subpoena for a month and nothing happened. On May 16th, Lively produced to counsel for Abel and Wayfarer parties a copy of the subpoena and all the documents that produced by Jones in response to the Vanzan subpoena. Go on to say, we note that this firm does not represent Vanzan for the purposes of this Vanzan subpoena is the subject of the motion. Vanzan is represented by Zuckerman LLP firm. This letter is not intended to be a response on behalf of them, but is rather provided for informational purposes to the court. They go on to provide then the letter that they wrote on May 16th, talking about how in the Wayfarer, Lively versus Wayfarer Studios case, that Blake Lively was indeed producing all of this information, and that Lively will soon produce documents bearing the base numbers 01 to 7413. So as I read it, that means that that is 7,413 pages. I don't think that's 7,413 documents, but somebody in the chat can correct me. I think that just means pages. They'll receive a secure FTP link with them, and they go on to say that it's the list of documents that Lively received in response to a subpoena to Jones Works. Again, take that piece of information, file it, the documents that Lively received in response to a subpoena to Jones Works, dated October 1st. Together with a copy of the subpoena, then Lively is reproducing the documents as she received them. For example, the Jones Works documents were produced to Lively without certain attachments and without metadata contemplated in the subsequently negotiated joint stipulation on the protocol for discovery of electronic stored information and hard copy documents. While Lively's forthcoming production reflects all metadata fields contemplated in the ESI stipulation, certain of the fields are not populated because the Jones Works documents lacked corresponding metadata. Now, if you have been involved at all on the internet in the past week, you will be sick and tired of hearing the word metadata, because this now became a huge big thing among the Baldoni supporters that, oh, it's missing the metadata. Oh, is it? They're asking for it for Vanzan because they need the metadata. So let's talk about metadata for a second. What she's referring to here is the ESI stipulation. So this is the agreement between all the parties in the Wayfarer complaint about how material electronic information is going to be shared between teams. And as part of that, there's a number of fields that are on here that is the metadata of the documents that are going to be pushed. So for instance, in terms of email, the send date, the time, if it's a document, the time that the document was created, it was last modified, start date of calendar entries for meetings, authors of the e-document, so on and so forth, right? Different types of document have these different pieces on there, all connected on here. And so part of it is, in terms of like text messaging and messaging, there's all these extra fields, what application it came from, what it was, you know, from, to, numbers, all of this stuff, right? A lot of information. Lively's saying, look, I've filled out all of these fields with each of the pieces of information I'm going to give you. Not all of them have data because they weren't provided to me with data. This ESI stipulation was not negotiated until May. So there's no way that Jones could have known ahead of time in producing to Lively, hey, here are all the documents and here's all the information you might need in a court case that's not going to happen for like another 8 months. And so I'll better give you all of that information included with them. So some of this information was not decided until long after. So of course it's going to be missing from those documents because it was never provided with the ESI stipulation in mind. However, Baldoni fans have lost their mind, saying that, she's trying to hide data, she's deleted data. And they've tried to say that it's related to the subpoena itself, when Lively's very clear it is about the Jones Works documents that were produced to Lively with certain attachments and metadata missing. That she can't provide what she herself was not given. Kim says they are upset they got caught 100%. All right. So then shortly after, Lively had produced this. We did that. Missing metadata. We did that. Oh, let's talk about the subpoena. Did I have Lively's subpoena in here? Yes. So Lively had produced this as part of her subpoena that she got. I can't remember, is it the first or second? This is the first set of requests from Wayfarer to Lively, and they had asked her for, quote, all documents and communications with Jones, all documents and communications you receive from Jones Works, all documents and communications you receive from Jones, the subpoena by which you have purported to receive certain documents from Jones, and all documents and communications relating to the subpoena by which you purport to have received certain documents from Jones and Jones Works. So this is what they've asked for, and this is what they've been given. And as she says in here, as they said in their piece, Lively gave them what she produced. So they're filing this motion to compel for Vanzan, but they already have the information. So Vanzan have also filed their response as well, saying that yes, they're trying to seek this information from a subpoena. The motion appears to be yet another attempt by Able and the Wayfarer parties to use these legal proceedings to continue their negative media campaign against Blake and her associates, this time by seeking documents from a third party that Able already possesses or are irrelevant to any of her claims and counterclaims in this litigation. The only justification Able offers is the Wayfarer's time-worn argument that there's something improper with respect to the Dole lawsuit Vanzan filed in New York State Court, which uncovered scathing evidence of Able and the Wayfarer party's retaliation campaign against Lively. But Able, and this is what I've been saying since this was talked about, offers no legal or factual support of this argument because there is none. If there was a legal problem with the subpoena, Friedman would have already filed something. It has not happened because there is no argument to make. If you could get the entire evidence that your opposition has on record tossed out because it was obtained in an improper way, you are failing in your duty to represent your client's best interest if you do not put a motion on the docket to get that evidence tossed out the moment you learn about it. At this point, right, May 16th, he has had that document in hand for 1, 2, 3, 4, 5, almost 7 weeks. 7 weeks, and there has been no filing from Friedman. I wish the Baldoni supporters would stop giving that man the benefit of the doubt. 7 weeks since you've had that subpoena and so-called able to prove the illegality, the crime that was committed by this, and you haven't filed anything on your docket. If nothing else, Wayfarer should be absolutely annoyed that they are paying this man their billable rate, that he didn't file it. Or the alternative, there's no filing because he's lying again. I mean, those are your two options. And we need to accept that reality rather than, oh, any day now. Any day, guys. It's happening. It's happening. It's crazy to me. Anyway, what's more, Able attempts to mislead the court by suggesting that two of the subsets of the documents request, the subpoena issued by Vanzan and the corresponding producing documents, are not fully in her possession when she knows they are. That Vanzan somehow has been incooperative, when in truth, here's where we get to the fun bit, Able abandoned the meet and confer process and filed this motion out of the blue after no communication for 3 weeks. They include their email meet and confer, where essentially, they're asking for this stuff. They give a recap of what they're seeking. Vanzan come back and basically tell them that, hey, you're seeking for these pieces. You stated that the materials that Able seeks from Manat are all subsumed by the subpoena to Vanzan, and therefore the subpoena to Matt may be unnecessary and you may withdraw it. We agree that it would be appropriate to withdraw the subpoena for Matt for reasons. So they were asking everybody for all of this stuff. They go on to say, you explain what Able hopes to achieve in these things, but as a threshold matter, we do not believe that the materials you're seeking from Vanzan are relevant to the underlying employment and contractual claims. We don't think that they're relevant. Even with your proposal to narrow the subpoena, you've yet to provide any legitimate basis for the relevance of the documents sought by those things. Moreover, Vanzan and are third parties. They have not been sued, nor have they sued anyone in Jones versus Lively litigation or any pending case. Thus, the documents they seek are available elsewhere and should be sought from the parties in the litigation. How many times have we heard that in a motion to compel from Wayfarer's side? They say, counsel for Able stated you'd be willing to withdraw the subpoena to Matt and the Maroney request if Vanzan would be willing to produce a copy of the subpoena issued in the Doe litigation and the documents in response. So they've said, look, we'll not seek them from Manat if you hand them over instead. We understand that you believe it would be helpful for Vanzan to produce the materials so you can resolve your concerns about whether any subpoenas and productions you received are accurate. As we said at the meet and confer, we discussed this potential resolution with our client. Okay? We would expect the Doe subpoena and documents to have been produced by the Jones parties. However, we've not received confirmation that Able has saw or received the documents you're now seeking through third-party discovery. So they're specifically telling her, look, you should have got these from Jones. You haven't told us if you did get them from Jones. And if you did, there's no point in us having to reproduce them to you, given that you already have them. During the meet and confer, you can express that you're unable to confirm whether you've received any of the Doe subpoena and produced documents due to the operative protective order in the Lively litigation. So they're trying to hide behind the protective order, saying, oh, we can't share any of that with you. You offered to review that protective order and to determine what information you could disclose about the receipts of those documents. And of course, we'd be willing to enter an agreement set forth in that protective order. So we agree to abide by the same terms in order to get that information and have that discussion with you. We reiterate our request that you confirm whether Able has received the Doe subpoena and responsive documents from parties, and if not, the status of that discovery. Assuming Able withdraws the other requests, we are willing to address your concerns regarding accuracy and either confirm the accuracy or produce the documents consisting of the Doe litigation and produced documents. So in their email, Vanzan are saying, hey, we will absolutely either, if you already have the documents, confirm the accuracy of those documents, or produce those documents if you don't have them. We just need to know, do you already have them? And they refused to answer this email that was, like I say, back in May 30th, and then weeks later, file a motion to compel. So the motion should be denied for two principal reasons. They argue that Able already has the relevant documents that she's seeking, and they then say, as to expedite this litigation and reduce the burden on the case, Vanzan will voluntarily agree to produce those documents. Hey, but you know what? In order to make this things faster, we'll repeat and produce the information you already have. Thus, the motion should be denied as to request 1, 4, 10, and 11. And as to request number 9, so request number 9 is for all communications between Vanzan and JonesWorks. They go on to say, look, you should seek those documents directly from JonesWorks before burdening a third party such as Vanzan for it. As to the initial matter, the motion is notable for what Able admits to it. Able fails to inform the court she abandoned the meet and confer process. Counsel for Able and non-party Vanzan conferred regarding the subpoena on May 27th. They then sent that email that we just talked about, offered to further confer and narrow it down. Able had already Counsel for Vanzan did not receive a response, even though at that time, Able had already received production of the subpoena and the responsive documents for a week before that. 3 weeks later, then she files the instant motion without any notice. So let me see if there's anything else that we want to talk about. Further, as a threshold issue, the motion should be denied because Able fails to demonstrate how the documents are relevant to her counterclaims. They have nothing to do with Vanzan. The claims arise from events Able says occurred when she was terminated and her cell phone was obtained in August 2024. Events in which Vanzan were not alleged to have been involved in anyway and took place weeks before the Doe's lawsuit was initiated on September 27th. And then finally, where's the last bit? To the wrong one. To the extent. It's in here a couple of times. Okay. Ultimately, the motion is consistent with Able and our counsel's pattern of using the court's docket to advance public relations narrative. And they say, if that were not the goal, Able would have continued the meet and confer process. and inform the court that she in fact possesses the information she now seeks. To the extent that Abel maintains she should receive a second copy of these materials so she can confirm information she already has, Vanzan agrees to reproduce those materials as previously offered. So, again, they already have the information from Lively. They are now requesting the information from Vanzan that they say is Lively. So they're requesting the same information, and they're trying to do it saying that they need to confirm the information, but you're getting the same information twice. If you're going to confirm, you need to get that list from Jones and compare it to the list you got from Lively, not from Vanzan. Getting it from Vanzan only just shows what you already have. But yeah, it's crazy. But Vanzan already, Wayfair already responded last night. It's so bad. It's so bad. All right. I don't think, did I not put up a response in here? I didn't. Oh, okay. Maybe I didn't. So they go on to say, look, in her answer and counterclaim, Abel contends that Stephanie Jones and her company collaborated with Lively to fabricate a sham lawsuit, blah, 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 pirate her phone. It's not Abel's phone. It's JonesWorks' phone. JonesWorks' phone. It's a company phone. It's not Abel's phone. Abel did not own the phone. I don't know how many times. This is so frustrating and maddening. Anyway, so they have subpoenaed them for this information, right? They don't. So as we talked about, they had admitted in their first piece that Lively had produced information. So now they're coming back and saying, okay, Vanzan has withdrawn its objections to seeking the documents. It didn't seem like they had any objections. They simply wanted clarification about whether you had them already or not. And then they go on to say, in light of that, they should be getting request 9, which is all of the information between JonesWorks and Vanzan, relating to the Vanzan action and subpoena. This reply also addresses the objections that Lively, a non-party of the Jones action, has gratuitously asserted in her letter. And they go on to say, okay, Vanzan doesn't explain why it objects to providing all of the communications given it's fine producing the other stuff. And the answer is obviously burden, right? They've already produced the documents via Lively. So reproducing those same documents is no extra burden. Going through all of their communications to produce all of their contact with Jones is a different burden. Also, it is important to remember here that these are two different entities. Right? When they talked about what they were going to get from Lively, we bring up Lively subpoena, the definition of you, right, when they're talking about you produce all documents between you and somebody else, was Blake Lively and anyone else acting or purporting to act on her behalf of anyone whose behalf she was acting, right? Do I have the Vanzan subpoena up? I don't think I do. I might have to go grab that in a second. But for Vanzan, right, the definition I think is like anyone that is like an officer or whatever of the company. So it's a different collection of people. So they can produce the information related to the subpoena and the documents they got from it because that's fairly easy for them to produce because it's already been produced. Oh, here we go. Where's you? You shall mean Vanzan, any of its directors, officers, shareholders, members, blah, 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 or anyone else purporting on their behalf. So it's a different subset of people, right? These are not two identical claims. They're two different entities. So argument for, Lively's produced the documents related to her, so you should just produce the documents for you. It's different burden, right? So going to say that Vanzan argues that Abel already has received the only relevant documents from Lively. The documents received from Lively included a purported copy of the subpoena and documents Lively maintains she received from Vanzan allegedly in response to the Vanzan subpoena. What's funny to me is they say, yes, we got a copy of it, but they say a purported copy. So they not believe the subpoena? So even though they're asking for the documents and to confirm this, even when they get the documents, they don't believe that they've got the documents, which is weird. It's very strange. She did not produce the documents, and they say she does not and cannot allege that Lively produced the communication sought by request number 9. She is not, and she can't. Even if she produces the information that was requested via her initial subpoena about hey, produce all of the information between you and Jones worked, it is only between you, quote, meaning Blake Lively and any of her agents. It cannot be the same information that is provided by Vanzan, where you means Vanzan, any of its directors, agents, which would be different people, right? A different subset, a collection of people from all their communications. There's no way that Lively can produce for this. So you are imposing a specific and individual burden on Vanzan by requesting those documents. I don't get why this is in here because this seems so simple and obvious. It's wild to see a lawyer argue this. Okay, they're going to say Vanzan cannot. Nor can Vanzan argue with a straight face that communications relating to the coordination between Jones, Lively, and Vanzan relating to the Vanzan action subpoena are irrelevant, particularly in light of Vanzan's implicit admission, so not explicit, that all other documents relating to the subpoena are relevant and discoverable. In fact, the communications concerning the Vanzan action and subpoena go to the crux of Abel's claim that Jones and Lively conspired to use her stolen information and use the Vanzan lawsuit to provide a veneer of legitimacy for Jones's transfer of stolen information. Again, it was a company phone. Any information on a company phone is owned by the company. Company owns the phone, owns the data on the phone. This is wild. Such communications will show as whether, as Abel suspects, that Jones provided the data taken from Abel's stolen phone to Lively before service of the subpoena, and the subpoena was a ruse contrived by Jones and Lively. You already have that information. You already have it. If Lively complied with this, she already gave you all of the documents, regardless of whether they were from the subpoena or before the subpoena, so you know whether any information was given to Lively before the subpoena or not. You already know this information. And if you suspect that Lively's not telling you the truth, asking for the same information from Vanzan, who is where Lively got that information, is not going to give you any different results. You need to get that information from Jones. It's very simple. This is wild that they put this in here. They go on to say then, even assuming that Lively produced or has possession of the communication sought by request 9, there's no rule that party sources must be exhausted before calling upon third parties to do relevant discovery. Lively can't produce those conversations. Lively can't. Jones has to, right? Or Vanzan has to, because Lively would have a different list. Lively's going to have a different list. The subpoena to Vanzan includes more people, right? Lively's not going to include a bunch of directors, assuming Vanzan isn't just like her and her husband. If assuming it's a broad company with lots of employees or whatever, that list would be much bigger, right? So that's why you can't. And to pull them in as a third party that are not involved and ask them to go through all of this is an extreme burden. So yes, they should be seeking it from Jones first. Where am I missing the piece? I thought I'm missing the big bit. Oh, here it is. Lively herself produced the documents Vanzan obtained from Jones pursuant to Vanzan's state court subpoena. So they are admitting here that Lively produced the documents Vanzan obtained. Why then are you trying to compel Vanzan to obtain the same documents? Why are you making this argument about you need to compare them? You've got the same documents. They go on to say here, in other words, Vanzan is Lively, or Lively is Vanzan, and there can be no legitimate contention that it is unduly burdensome for Vanzan, i.e. Lively, to produce communications responsive to request number 9. They can, because of the reasons I explained. But if Lively is Vanzan and Vanzan is Lively, then the information that Vanzan got in terms of the subpoena and the documents is the same. This is so frustrating. It also destroys their other argument that they had originally, which was their whole argument about the Vanzan subpoena is Vanzan has no interest in Abel's text messages, has no right to them, is not involved, all the rest of it. But if, as they're alleging here, that Lively is Vanzan, the two are the same, right? The Vanzan entity is nothing more than a shell corporation that is headed by Lively and possibly her husband. Then Vanzan does have a vested interest in getting Abel's communications in their, investigation to litigate against a smear campaign and sexual harassment retaliation against Lively. So they're undermining their own argument again in trying to say that, well, Lively is Vanzan, and so Lively has to hand over the communications because she's directly involved in all of this mess. Though again, the fact that she's involved in the Wayfarer lawsuit doesn't mean that there isn't a burden for her to produce those communications in the Jones versus Abel lawsuit. Different thing. Also a weak argument. But the idea that Lively is Vanzan then absolutely destroys their idea that Vanzan is this unrelated company that has no business requesting text messages from Jennifer Abel. If Vanzan is Lively and you want to use those entities interchangeably, like in terms of legal responsibility, then Lively asking for Jennifer Abel's communications about a smear campaign against Blake Lively is highly relevant. Like, try telling this to their fans, says Kim. Yeah, no, they're not the best with that. Like that, this would be logic and reason, and that doesn't necessarily go well. But what's going to happen, of course, is what inevitably happens is this is going to be ripped apart when it comes to the judge. They're going to lose, and then they're going to blame the judge for being biased rather than Wayfarer for not bringing a single factual basis for any of these nonsense claims, continuing to play PR. Yeah, so I don't know what they're trying to do here. I mean, they may have to hand over the request 9 documents, but I mean, like, even again, if Lively's already complied with it on her side, they're not going to get a lot that they don't already have. So we'll see. But again, I think that it's strange that I didn't see a lot of in Vanzan's response that it was privileged. I don't remember that being a large part of. Yeah, I mean, they don't even argue it, which is not great. There should be somewhere in here some piece of argument about privilege. I guess maybe it's in the email? Where's their email? Maybe they're arguing it in there. Yeah, you raise concerns involving burden and privilege. Okay, so they did at least raise it in the meet and confer. Because we want to make sure that they still got that argument, and if they didn't bring it up, that would be a problem. But yeah, I mean, I feel like a lot of that stuff is probably privileged because it was them investigating ahead of doing litigation, but we'll see. But that they have sat on the subpoena and the documents for it is wild. And also, if they have all of the text messages that Abel, that Jones Works gave to Blake from Abel, why have they also not kind of filed anything about that and shown off like, hey, here's all this evidence? Remember, their whole big claim about the New York Times was that Lively had ignored this mountain of evidence, this mountain of text messages that show they were innocent and didn't do it. We've not seen those. If they have all the messages that Lively has, again, why have we not seen anything from there? So, Muckamuk says, no, thank you. I'm using the last 3 shreds of my sanity. We are all just running on fumes of sanity with this case. All right, so let's wrap this up with the last piece here. I talked about, you know, if you were wanting, you wanting fees and sanctions and the rest of the stuff to get excited, because yes, that is the other thing that happened this week. Sloan filed for a motion for fees. And again, this just all reiterates that all of this lawsuit has been just nothing but PR, right? I don't think I need to bring up anything else in here, do I? Oh yeah, timeline, page 143. All right. So Sloan is basically now filing for fees. Now, if you remember when the motion got dismissed, the Judge Lyman had said he was going to interpret stuff using California law because it was a little stricter. But he wasn't making a judgment on a lot of the things based on whether California law or New York law applied. So even though he dismissed, he wasn't going to decide on fees because that would need to be, right? Those claims for each of the individual defendants would need to be decided based on the law that applies. So Sloan has now moved to do that. She's making the argument that New York law should apply and its anti-SLAPP statutes should apply, and that as a result, she should get fees and have her attorney's fees paid. All right, so let's go into it. At this point, I think we all know the background, right? You know, she goes on to say that, look, Wayfarer parties for months wrongfully refused in discovery to identify their sources or produce anything to support their allegations. Discovery from third parties proved that their main allegation which the Wayfarer parties repeated and sensationalized through the court filings, was utterly false. This is a big problem for them when we're coming to this, because again, if they were on the up and up, they would have provided discovery, right? But what happened was Wayfarer delayed, refused, didn't want to provide discovery, and Sloan basically got all the evidence to show that Wayfarer were lying through a third party, right? So there's an incurred cost there. There's the fact that Wayfarer knew what they were doing was wrong. They knew the reality of the situation and didn't openly confess to it. That all really damages their case when it comes to what they were doing wasn't malicious, what they were doing shouldn't invoke sanctions and fees. I think this could be a sign of how things go. Anyway, we know about the James Vituska conversation. We'll get into it as we get into the actual arguments for it. Oh, no, never mind. My notes say we get into it right here. Where are we? 296. The court dismissed the claims against him on the terms that Sloan did not commit a tort. In addition to the gaping legal deficiencies, the Wayfarer parties' discovery has confirmed the facts allegations against Sloan were complete fabrications. We covered that piece. So yeah, pretty damning that yes, they didn't bring a single actionable claim, but that Sloan never actually did any damage to them either. Talked about Vituska, you know, confirmed that by the Wayfarer's own admission, any claim that Lively was sexually assaulted was an unsubstantiated accusation. They go on to use, you know, the full quote from Wayfarer, using their words about it against them. It is simply unbelievable that any Wayfarer party or counsel that drafted that allegation or signed those pleadings believed in good faith that Sloan did indeed make an accusation of that case. Given that the Wayfarer party's claims were baseless, it was clear they were filed for an alternative purpose, to distract from their own misconduct and silence Sloan's communications with the press concerning Blake Lively's claims of sexual harassment and retaliation. By subjecting Sloan to costly litigation and attempting to ruin her reputation through false and defamatory accusations masked as legitimate court filings. And then goes on to talk about the slap laws that are going to back her up and give her fees. Page 10. The Wayfarer parties knew, or ad hominem should have known, that sexually assaulted was Vituska's own characterization of details in Lively's administrative complaint, and not any words that Sloan ever uttered. Indeed, the screenshot embeds an image of Vituska's August 8th conversation with Sloan, which includes no allegations of Sloan by Sloan of sexual assault. Vituska then expressly states that Sloan never mentioned any allegations of sexual assault in the text messages that they showed, which I think we can just quickly, which we can quickly bring up, right? Because I've memorized all of this nonsense now. Page 14, in case you're playing along at home. You know, never once did she mention anything about sexual harassment, right? So, yeah. Many conversations with Blake, never once did she say anything about sexual assault. So, by their own screenshots, they should have known that all of this was junk. Now I gotta go back and try to find where we were. There we are. Oh, never mind. They had it right here. Never once did she say anything about sexual assault. Okay, so they knew. Making things worse, the Wayfarer party's pleading was littered with irrelevant and unfounded allegations meant to solely inflame the public and severely harm Sloan's business. For example, the Wayfarer parties recklessly alleged that Vision PR was once backed by Harvey Weinstein. Which also was part of what they had tried to go after her for in their own timeline. Page 143. Is it this one? There it is. In a conversation between Justin Baldoni and Melissa Nathan, apologize for the potato quality, they actually say here, do you believe Leslie? Can you spin the crisis PR thing so it's factually? There's been lies put out up against powerful people, just protecting myself. Tag reps a lot of people, and that headline was just to smear more. So this is in response to the Hollywood Reporter headline about how them hiring Tag and Melissa Nathan, right? He's hired Johnny Depp's PR crisis person. Nathan, in response, says, do you want to see a headline? It's another Hollywood Reporter article talking about the connection between Harvey Weinstein and Leslie Sloan, to which he says, so how do we say Blake and Ryan hired the Harvey Weinstein publicist? So even back in August, I think this is August 14th, 15th, somewhere around then. What does his own timeline say? 14th. So August 14th, they were plotting to put this whole like Leslie Sloan is connected to Harvey Weinstein's smear. And so that's what Sloan is talking about. Like they were put it in their complaint as well. It's all part of the same smear campaign that they were trying to feed and put and fuel this. To compound the damage to the Sloan parties, the Wayfarer parties and their council launched a defamatory campaign, going on talking about how she was planting negative and complete fabric stories in the media. They have never shown any evidence of this. I'm trying to find my other piece of the note and I'm lost now. How are we doing, chat? You're all quiet. As it talks about how they should have known their claims were without merit, and that, you know, they had incurred costs. Wayfarer parties can cause the Sloan parties to incur substantial attorney's fees and costs while knowing their claims lack basis of fact. She brings up the point that they argued to stay discovery pending the motion to dismiss, and that the Wayfarer parties opposed because they wanted to get all of that discovery from Sloan before they knew that their pleadings would get dismissed and that they had no case against her. She makes the point that had Wayfarer parties consented, the fees that the Sloan parties incurred defending this lawsuit would have been dramatically reduced. So arguing that she's going after these fees, but part of it is those fees were incurred entirely because Wayfarer would not allow her to allow a stay of discovery. And had they done that, they would be on the hook for a lot less fees right now. As discovery progressed, it quickly became clear that the Wayfarer parties knew that their claims were without merit. The Wayfarer parties' characterizations of their own claims became increasingly vague rather than increasingly clear. For example, in the amended complaint, the Wayfarer parties alleged that Sloan said Lively was sexually assaulted and that she seeded stories calling Baldoni a sexual predator. But once it became clear to Wayfarer parties they had no basis, they began to argue only that Sloan seeded stories to the effect that Baldoni is a sexual predator who assaulted Lively. Strikingly, during a meet and confer, the Wayfarer parties counsel refused to even confirm whether they were still alleging Sloan had ever said the word sexual predator or sexual assault in reference to Baldoni, nor would they offer any other clarification as to what the Sloan parties' allegedly defamatory statements were, which was, you know, we've talked about, was a huge problem for them, is that they alleged defamation but could never actually point to what that defamation is. They then forced to incur substantial costs trying to even attain a modicum of clarity regarding their claims. And then their inability to support their claims was confirmed in discovery when, as the Sloan parties argued all along, the Wayfarer parties' allegations against them were flat out lies. For instance, there was never a shred of evidence produced in this case connecting Sloan or her company to the New York Times article, nor could there be, since, as repeatedly explained, Sloan had zero involvement in its publication. The Wayfarer party only ever attempted to connect Sloan to two reporters, and she did not make defamatory statements to either of them. As to Sarah Nathan, who's Melissa Nathan's sister, the communications confirmed that Sarah Nathan told Sloan about the sexual harassment allegations, not the other way around. So remember we talked about like the 3 HR complaints that a lot of the different press outlets were talking to Tag and Wayfarer about, right? Well, it looks like Sarah Nathan was the first one to ask about them, because those other pieces, I think, were around August 11th, I think, if I go back to his timeline. I thought when they started getting all of that stuff about the HR complaints, it was around then. Maybe not. Maybe it was a little bit after. Yep, there it is. So it was that August 14th. So August 14th is when they start getting asked, and they talk about like it. I think there was also one from the Independent. I don't know if they show it in here around that same time. So Sarah Nathan asking on the 8th shows that she was a little ahead of the game. Also potentially suggests that it was Melissa Nathan who seeded this and seeded it through Sarah. But she told Sloan, saying that she'd heard 3 things that Baldoni did were on set that, in her words, all a bit creepy. Sloan then, on August 11th, Sarah Nathan forwarded Sloan an anonymous tip that Page 6 had received, which said, among other things, Baldoni had made Lively uncomfortable on set. The first time Sloan discussed the sexual harassment allegations with the journalist was when Sarah Nathan told Miss Sloan what she had heard. Even though Sarah informed Miss Sloan of the underlying conduct, not the other way around, Sarah Nathan's sister Melissa had twisted those conversations to brazenly accuse Sloan of planting stories about Baldoni, knowing well the opposite was true. And then, as we know, we talked about with Tusker, Sloan never told him that Lively was sexually harassed. But I guess we missed the other piece that I want to talk about. But yeah, so he'd used that phrase on his own accord. They knew that it meant by his use of the phrase sexually assaulted before they wrongfully attributed those words to Sloan and filed a complaint about, so that they never investigated it. And they should have known this well before they filed their lawsuit. So they wanted to, they talk about it getting dismissed with prejudice. I don't think we talk about this because it's all like slap stuff and like I don't fully understand all of this piece. So legal stuff, lots of legal stuff. The Wayfarer parties lacked a substantial basis in law. There's no question that the Wayfarer parties' claims lacked a substantial basis in law since the court dismissed those claims without leave to amend. So that by itself is sufficient to satisfy the substantial basis of the standard anti-SLAPP suit. But they go on to then say there's also a substantial basis in lack of substantial basis in a fact. Where are we? Did I mess up? What page? 23. Indeed. Okay. The closest that Wayfarer parties came to stating a plausible defamation claim against the Sloan parties was their allegation that Sloan told James Vituska that Blake was sexually assaulted. But in addition to the defenses of that allegation, even assuming its truth, Vituska is now sworn under penalty of perjury, as Sloan argued all along that sexually assaulted was Vituska's chosen words and not words that Sloan herself had ever uttered. Vituska unequivocally testified that Sloan had never told him that Lively was sexually harassed. But then they go on to say, as further evidence that the allegations attributed him were unreliable, Vituska explicitly instructed Brian Friedman not to reference him or the Daily Mail in support of the Wayfarer party's complaints. See Exhibit A. She attaches a screenshot of a message from Vituska to Brian Friedman saying, "Hi Brian, this is James Vituska. I need to make it clear that I do not want to be involved in this lawsuit in any capacity. Being part of this suit or having any association with it, even if my names are removed, will jeopardize my job and career. Please ensure I am fully excluded and mention of the Daily Mail in connection with myself before filing." But that didn't happen because in the original New York Times complaint, they literally put his name on here in the original version of it. James Daily Mail, include all of his screenshots of stuff. Now, by the time, I think 2 days afterwards, they filed a redacted version of that. And when we come to the 179 page complaint, where are we? We just get Daily Mail reporter instead. But even so, Vituska's message was, don't include my name, don't include me, please ensure I'm fully excluded in mention of Daily Mail in connection with myself. So even just taking out his name, even if names are removed, will jeopardize my job and career. They did it anyway. And it looks like people have been talking about James Vituska's email. Doesn't appear to be working right now. It bounces back. Now, it could be just some weird IT configuration setting. It could be that Vituska is no longer employed at Daily Mail. He did write a story fairly recently, I think like June 26th. So if that did happen, it happened fairly recently. But yeah, it's wild that they were told specifically not to use this information, not to use his name, not to use those screenshots, and yet he still put them into the lawsuit. 25th, sorry. The 25th is the last article written by Vituska for the Daily Mail, but we've not seen anything else. And then, like I say, this email address does not longer work, and I believe his Instagram has gone too. So interesting. Don't know that that means anything, but it is a data point. So anyway, yes. Given the ambiguity of the text message and available information directly contradicting the Wayfarer party's interpretation of it, the Wayfarer parties certainly should have investigated its meaning before relying on it as their sole basis for a defamation lawsuit against the Sloan parties. Goes on to say, here's why they should apply. You know, like I said, we talked about why, you know, she's arguing why New York law should apply. And then the headline right at the end there is that they are seeking approximately $1.3 million in attorney's fees and approximately $40,000 in costs. This is just from Sloan, right? You're going to expect these motions also to come from possibly the New York Times, possibly from Blake Lively, Ryan Reynolds, as everybody involved is going to come after them for these fees. We'll see. I don't know when the schedule for this is going to be decided. I don't know if Wayfarer, I assume so, get to argue back. And we'll see. We'll see how it goes. Monkey Mike says, gotta run. We'll catch the rest later. Don't worry, that is pretty much it. We're about to wrap up, so we'll close out with some chat. You will not miss much, but I hope you have a great day. So yeah, that's it for this week. That is everything that has kind of gone on. So interesting to see how things go with, like we talked about, there's a lot of production that needs to happen this week ahead of those depositions. So we got a lot of deadlines there. July 1st is the deadline for substantial completion of document discovery. Then we got those motion to compel the Wayfarer third parties by July 1st, and then the tag employees, I believe, right, by July 7th. And then depositions start on Lively's side on July 9th. So we'll see if anything comes out from that. Cool. All right. Well, appreciate you, chat. Thanks for hanging out with me. Kim says, I was legit embarrassed by the response. What do you mean that Lively's Vanzan, but we already need Vanzan to produce documents that Lively has already given to us? Yeah. I did a meme and I don't remember, and I forgot to put it up in here. Let me see if I can quickly grab the meme while we're talking. Yeah. Did I put it up? I didn't. Oh, okay. I didn't do it and didn't put it up. I don't think I have it in my folder, so you're gonna have to just miss it out. Maybe I will post it to threads later today as we do for it. Appreciate y'all hanging out with me. Thanks, Kim. Thanks, Muck and Muck. Thanks, Kira. TR, My Lady, Emily Bellis, King Gator. What else we got? Scrolling up through, I think I said My Lady. Also to Donald T, Caspian, thank you for hanging out. Yeah, so we'll do it all again next week. I keep saying this, maybe, hopefully, next week will be a quieter one. Next week will finally be me talking about the amicus briefs, talking about Dalvo, talking about sexual harassment. We're going to cover it in terms of employment law, because I do think there's a massive misunderstanding about what that looks like, and especially quid pro quo. I think it's important to understand as a background for the basis for what we're talking about here in sexual harassment, but also just, you know, generally these abuse tactics, Dalvo. You know, I saw somebody talking about how, oh, if you defend yourself, that's Dalvo. No, Dalvo is a specific set of techniques. We're going to talk about them, what that looks like, how to identify it, and how it relates to those amicus briefs that were filed and how it relates to this case. So yeah, I think that's that. So I appreciate y'all for hanging out with me. Thank you so much. If you like what we do, as always, click the like button, make a comment, share the videos with somebody else to make sure that we're spreading this information. And otherwise, I will see you on Threads, on Twitter. I refuse to call it X. And I will see you here next week as we cover all of the updates. I hope you have a great rest of your day. Thanks for hanging out with me. And I will see you next time. Take care.